Go ahead.
All right, welcome everyone and good afternoon. It is a real pleasure to welcome everyone in the room and those who are joining virtually to today's session with the program on education policy and governance. I'm Payman Rahanafard, and I'll be facilitating these sessions throughout the fall, and really excited to introduce our guest speaker today. I'll just quickly note before we jump in, for those seated here in person, there's this overview of the future sessions we have this fall, and it's also on the website for those that would like to join us in the future, either in person or virtually. So please take a look at that. To jump in today, we are joined by Rocco Testani, who is an attorney at Eversheds-Sutherland. And just to kind of give you a quick intro on Rocco before he does before he presents, and then we'll have a Q&A session. Rocco is a partner and the co-head of global litigation at Eversheds-Sutherland, which is based in Atlanta. He is the co-leader of the firm's U.S. business and commercial litigation team. He leads the education sector team, and he recently completed his term as a member of the firm's executive committee. He has represented state and local government officials across the country in school finance matters, including education funding, which we're going to talk about, and adequacy litigation. Rocco also represents clients in litigation ranging from complex business disputes to civil rights and constitutional law cases. He has a broad range of experience in many types of cases, including bet the company business litigation matters, as well as in high-profile public policy and governmental disputes. We're really privileged to have Rocco join us today, and I'm going to turn it over to him to get us going before we jump into a bit of a conversation.
Thanks very much for the intro, and it's good to be here to talk about adequacy and equity litigation in public schools. I want to start with the short history of American education litigation, which of course starts with Brown versus Board of Education, where the U.S. Supreme Court found that separate but equal school segregation by law violated the equal protection of the 14th Amendment. And over 50, 60 years of remedies were put in place by the federal courts to dismantle that structure. About 20 years later, a different kind of case was brought to the federal courts, and that was San Antonio versus Rodriguez. The claim in that case, not racial segregation, but the argument was that education was a fundamental right under the federal Constitution, and that disparities on the basis of wealth, that is poverty, that those should be treated in the same way as distinctions of race. And this involved disparities in funding in the Texas school funding system. The Supreme Court, in a 5-4 decision, rejected the argument that education was a fundamental right under the federal Constitution, and also rejected the argument that wealth is a suspect classification under the 14th Amendment. So the federal courts, as of the Rodriguez decision, really were closed to arguments about differences in funding across school districts as a basis for a claim under the Equal Protection Clause. So the action in these cases turned to the states, and the key and the first big state case is Serrano versus Priest, which was a California Supreme Court decision. And the argument in that case was that under the California Equal Protection Clause and under its education article, that the disparities in funding across the state of California constituted a violation of those provisions. And one of the key sort of evidentiary examples in that case was that in the Beverly Hills School District, 1 mil of tax would raise $50,000. And in Baldwin Heights, a poor community east of LA, 1 mil would raise $3,000. And so obviously, poor community could tax itself into oblivion and still not raise the amount of money that could be raised in Beverly Hills. So that kind of disparity, that lack of equalization across school districts was the focus of that case. The California Supreme Court found that those kinds of disparities in resources and in the tax burden across the state for education support violated the California Equal Protection Clause and also violated the education article. So Serrano is kind of known as the granddaddy of the equity cases, the beginning of the equity cases. The next case I want to touch on is Rose versus Council for Better Education. And this is a late 1980s decision from the Kentucky Supreme Court. And it really was ushered in what we call the adequacy litigation. And the issue in Rose wasn't, as in Serrano, equalization, that is, disparities in resources. The question in Rose was the funding in Kentucky adequate to meet state standards, educational standards? So it was very much focused on the outputs. What outcome do we want from public schools? And is there enough money in the system to achieve those outcomes? And so the Kentucky Supreme Court struck down the Kentucky school finance system, that it violated the adequacy clause of the Kentucky Constitution, and said that there would need to be 7 capacities that students should be able to achieve once they finish their K-12 education. And that involved oral and written communication skills, knowledge about the economy, understanding government process, self-knowledge, training in the arts, vocational and academic skills, and ultimately to be able to compete in the job market. So these were the framework of what would be needed to be established in order to prove compliance with the Kentucky Constitution. And those that are called 7 capacities have really been used many, many times in follow-on litigation in other states. So what provisions of state constitutions are we talking about? Like, what are the courts and what are the plaintiffs focused on? What are the provisions at issue? I put up here 4 examples. All of these states, and Pennsylvania, I guess, is the 5th example, of where there's been this adequacy litigation over the last 40 years. And Massachusetts has very flowery, old-timey language that goes back to the 1700s. That you can see here that it should be the duty of the legislature to cherish the interest of literature and sciences in all seminaries of them, especially public schools and grammar schools in the towns. So that provision was the focus of a 1990s case called Hancock that involved the adequacy of funding in Massachusetts. The court found it was inadequate and require additional funding under that provision. But the point I'm making here, I guess, is that's the language the courts are dealing with. It's very broad and it's in many ways anachronistic language, but that's what the courts are being called to interpret. New York, a very broad provision, talks about maintenance and support of a system of free common schools. We were involved in the case in New York called Campaign for Fiscal Equity that went on for a number of years around 1999-2000. But that was the focus of that case, that provision had been violated. And the court ultimately concluded after a lengthy trial that it had been violated as it relates to funding for New York City schools and ordered a remedy. And so there were years and years of remedial proceedings that followed as a result of that provision. New Jersey, you can see maintenance and support of a thorough and efficient system of public schools. Again, New Jersey sort of is the poster child of cases that never end. This case has been going on since the early 90s, and it's resulted in 20+ New Jersey Supreme Court decisions back and forth between the trial court and the appellate courts over whether the remedy in that case has been sufficient or not. And so that case continues, called Abbott. Pennsylvania just finished a case a couple of years ago, and a similar finding that it's called William Penn, that case, and the court found that the system of funding in Pennsylvania was inadequate. And that is being dealt with legislatively. Florida's an interesting one because unlike the language of these other provisions, Florida actually had an updated education article in 1998 as a result of a voter referendum, an amendment to its constitution. And the effort there was to try to put a little more meat on the bones of this provision, to try to be a little more prescriptive or directive about what the state was required to provide. So you can see the language there, very focused on not just, uniform, efficient, safe, secure, but also a high quality system of free public schools that relates to an outcome, to obtain a high quality education. So you see both an inputs focus and an ultimate outputs focus there. That case, as a result of that provision, we had a case there that started in 2009, finished ultimately in 2019 with a Florida Supreme Court decision concluding at the end of it, after we had a trial and obviously many years of proceedings, that the state complied with that provision, and in fact that provision was not a justiciable question. And we'll talk a minute about what that means in terms of the court's finding. So what are the kinds of claims that are brought in these cases? What are the nature of the claims? The first one that I put on the screen here is really the Serrano, the Rodriguez kind of case. It's an equity case. And that is that school funding should not really be overly dependent on the wealth of the school district. And that's, kind of a straightforward argument that if it's too dependent on local property taxes, there's not sufficient equalization, then that's a problem from an equity standpoint. The Rose cases and the cases I've touched on in New York and in Massachusetts and in Florida are the adequacy. And here the focus is on the relationship between school funding and student performance outcomes. And so the big issue in these cases really revolves around causation. Is the level of funding producing or causing the issues, whatever those might be? Low performance on test scores, low graduation rates, lack of college going. Is there a relationship there that we can identify? There's a big focus on the inputs, or the quality of the inputs, teachers being the principal one. Teacher experience and quality, what does that look like? Are the teachers in the poor schools less experienced? Do they have lesser education? Do they come from less prestigious institutions? What is that allocation of the teaching workforce? Class size, big issue. Are the class sizes too large? Do we have overcrowded schools? Do we have classrooms where teachers are unable to manage their students? Do we have lower class sizes in schools with a lot of low-income students, where the studies tend to show lower class sizes are beneficial? Obviously, there's a focus on curricular offerings, and are they rigorous enough? Do the low-income schools have access to, high-level IB, advanced placement courses? Is there a good allocation of that? Textbooks, instructional materials, are those up to date and appropriate in the schools? And then a big focus is often in these cases on the outcomes for low-income students and students with disabilities and English language learners. Are they meeting their IEPs if they're a student with disabilities? Are they mastering English if they're an ELL student? So what do the plaintiffs ask for at the end of these cases? What they ask for is declaratory relief, declaratory judgment that the current system of funding schools is unconstitutional under their state constitution, and they ask the court to impose an injunction to require the legislature or the governor or some combination of them to provide more funding. That's the bottom line. As far as defenses in these cases, this has been my work, so I'll focus on defenses to these cases. They're really in two major buckets. The procedural and legal defenses that are almost always asserted at the beginning of these cases. The first one is really a separation of powers point, which is that courts are not particularly well positioned to make decisions that are fundamentally policy oriented. That is how we fund schools and what programs are best in schools, how to improve student performance. The issue here, of course, is that in most state budgets, 30 to 35% of the state budget is dedicated to K-12 education. Another 30 to 35% is for Medicaid in states. So you've got about 70+% of state budget consumed by basically two programs, education and healthcare. So you've got 30% left for everything else, and that's funding the government, roads, public safety, higher education, disaster relief, top of mind right now. A lot of the things that are needed that government provides is really a minority of the budget. And so the question in these cases, when presented to a court of law, is, look, I'm the governor, I'm the legislator on the state board. We've got lots of other things we got to be worried about as a state. And we can't double our taxes, that would never fly in our state. So we've got to make choices, and public policy fundamentally is a cost benefit analysis. And these are intensely political questions and should not be decided by a court. So that's one of the early defenses that is asserted in these cases, and usually on a motion to dismiss. A couple of other defenses that are raised, if it's a public interest group bringing the case as a plaintiff, do they have standing? Have they been harmed in a way that allows them to bring a lawsuit? The next one that is often brought is who are the defendants in the case? If it's just the State Board of Education, or if it's just the Department of Education, what authority do they really have to make a difference in any of this? What about the local school district that the students attend? What about the legislature that appropriates funding and adopts a budget every year? So those are some of the preliminary defenses that are brought in these cases initially. On the merits, I'll start kind of on what I would call a hybrid defense, and that is if we get past the question of justiciability, so you lose on the motion to dismiss, the court concludes that I can hear the case, right? It's not a political question. What standard should I use to evaluate the system that I'm judging? And should I look at it sort of as though I were making the decision about what was best or what's required, or should I be deferential to the other branches of government and their decision making? So in looking at the evidence that will be presented in the case, we will argue that there ought to be a deference paid. If you're not going to throw the case out, at least defer to decisions that are being made by the political branches of government about how schools are to be funded. That's important because in litigation of this type, and really all litigation, who has the burden to prove can often determine who wins the case. And so if there's a higher burden to prove your case, because this involves sensitive political and policy questions, which is our argument, that can often be determinative because the plaintiff can't meet that burden. So that's an important aspect of the defense. The next one really is the central issue. If you get beyond all of the legal and procedural defenses, the next one is causation. That to me is the key issue in this case, and it's the most interesting of the issues because it really gets into the social science about the relationship between school resources and student performance outcomes. This is an age-old question that goes back many, many decades, and I think to say it's unsettled is probably an understatement. I think it is unsettled, and there are studies that point in different directions about that, the relationship and how money is spent and where it's spent and what effect it has. And that's the key part of the expert witnesses in these cases. That's the part of the presentation that really depends on the experts. Another part of the merits would be to look at, let's say a state isn't performing well currently, but let's say they've been improving. That'll be something that would be focused on, is to tell the court, look, it's not where we want it to be, but it's making progress. And so we don't need to and shouldn't be intervening as a court when the policies are working, even as we're getting maybe slow progress. We look at comparisons. Are there some school districts, schools that outperform others with similar resources and similar demographics? And why is that? Why is that? Again, that goes right back to the causation question, which is if some districts and schools are able to get reasonably good performance and others can't, why is that? If it's not a difference in resources, what is it? So we talked a little bit about experts. Again, this is a central focus to give you an idea the case that I worked on in Florida that we tried for a month several years ago, we had on the defense side 10 experts, and the plaintiffs had about the same number. So again, that was very much the focus of the case, the experts. And who are these experts? They're economists, they're school finance experts, they're statisticians. We have experts on testing, public policy experts, a lot of experts that have come from when I say this, the field, they come from the schools, they come from running school districts, and they'll bring their various opinions. I've kind of put it in two major categories: what I call soft expert evidence, which is what I know because I've seen it, and I'm going to tell you about what I think works and is important in schools. And then the more statistical, computational, data-driven kind of experts that look at both studies that were done not for the case and studies that are being done for the case. And so that's the kind of presentation that is utilized in these kinds of cases. So some of the big issues that are addressed are the big issues that we see, sort of in general in public education. And that is, clearly money is essential to running schools, but how much is needed and how it's spent are questions that are raised in these cases. Would more make a difference? And the question is, how much of a difference and how much more would make a difference? And in weighing, again, the policy trade-offs and the cost and benefits, which has to be done in public policy, how much more would make a difference that makes a difference to us as a state or as a community. Again, we talked a little bit about what are successful states, what are successful school districts, what are the features that those and attributes of those places in terms of how they run schools and run their policy. Are interventions based solely on money the most effective ways to improve schools? Or are there other interventions, choice, competition, accountability, other kinds of measures that also can be beneficial? The next item is very important, which is how do we understand and make sense of the Common Core standards? I talked a little bit at the beginning about what is the legal standard to use in these cases? What is the court supposed to focus on? And the plaintiffs will say, well, the court should focus on what the state has adopted as its standard. And those are the curricular standards that every state has. And they have, of course, tests that are aligned to those standards. And those are all pretty much on a 1 to 4, performance level. And so if large numbers of students are not proficient on the state tests, what does that say about the quality of the public education? What does that say about the adequacy of the public education in that state if large numbers of kids are not meeting those standards? So there's a lot of discussion about what do the standards represent? What do the cut scores represent? How are they set? How should we interpret them? So there's a lot of that kind of debate in the cases. Talked a little bit about the fact that state budgets are not solely dedicated to public education or K-12 public education, and there are other needs. And so we don't have an unlimited amount of funding. What should we focus on? How important is healthcare in relation to student performance? Maybe those things go hand in hand. How important is criminal justice in terms of student performance? Those things can go hand in hand. How important is social services to public education outcomes? Those things can go hand in hand. So, but budgets are, set. And so how do you make those choices and who should make them? I wanted to give you kind of just a little bit of a flavor of some of the evidence that has been used in these cases. And I will say, it's a little biased towards my perspective, which has been a defense perspective, but it'll give you a sense for these. And certainly they provoke discussion, as they do in the cases, as to whether they're a complete picture. And I will say they are not a complete picture of what's going on, but they are a picture of what's going on. The first one is, what do we know about the trends in spending on public education, K-12 public education in this country over a long period of time? So what this chart shows is that going back 60 plus years, in real terms, spending on public education on a per student basis has been significantly increased. Now, that's both true in overall dollars, which is the top line. It's true state and local dollars. Federal money's been more flat, although if we did a chart from 2020 to now, it'd be a steep increase because of the COVID relief money. But the point of this is to set the table, to say, what do we know about the trends in funding for public schools over a long period of time? And this, is the way it looks. And then we will say, look, what do we know about performance in public schools over a long period of time? And this is NAEP performance for 13-year-olds, long-term assessment, both reading and math, the most current information we've got. So the reading one is the top panel. And, it's flat, basically, over a 50+ year period on NAEP. Flat or down, I guess it's certainly down since 2020 to 2023. Some of that is probably COVID related, but you can see the pattern there. Math over time has been slightly better, although in more recent years has been flat to down. So again, start with the money picture, the funding picture. We turn then to the performance picture. And again, this connects back to the point I was making about causation, which is there do we see relationships here? And you might say we'd expect maybe more improvement by spending more money if it were true that there was this kind of linear relationship in those two things. ACT, high school kind of tests are more difficult because there's a self-selection there to some extent, but still it's a measure. And what we know is that's been flat or down for the last several years as well. And so that's kind of just a snapshot of the pictures. This is a chart we used in the Florida trial. And although it was not done for the Florida case, I will say, but I was happy to take advantage of it because it really made a point that we wanted to make, which is here we're displaying what's being displayed is on the vertical axis improvement in NAEP scores over a 20-year period, 1990 to 2011. The horizontal axis is increases in spending in real terms over that same period. And it arrays the states according to both their spending pattern increases and their performance increases. And one of the words from the Florida Constitution that we looked at earlier was efficiency. That's one of the standards that was embedded in the 1998 Constitution. So this was going to that point, which is, Florida is a state that didn't spend much more money over this 20-year period in real terms, and yet had among the highest performance improvements. So, obviously our point here was to say the system that Florida has is working. It's efficient and it's resulting in good output. So what they're doing is working. Please don't disturb it, court. And you can see the other states, and certainly there are states that spent a lot more money and didn't get much improvement. There are similar states, you can cut this up any number of ways, of course, similar states to Florida, demographically, and maybe, even in terms of labor markets. North Carolina, Georgia, close by, didn't get quite the improvement, spent more money, Georgia in particular. So you can see the question we're trying to answer here is, if you thought there was a close relationship between improved funding and improved performance, you'd expect to see you'd expect to see a pattern here, and there really isn't a pattern. Some states spent a lot more money, got very little for it. Some states spent a lot more money, did pretty well. Maryland, Massachusetts spent a lot more money and did pretty well. But then you get Florida, spent very little, did just as well. So what do you make of that at the end of the day? I did want to touch on kind of lastly here, I'll kind of open it up for questions or comments. As I mentioned, causation is a huge component now in this litigation. And so one of the responses from the plaintiffs or the advocates who bring these kinds of cases is those charts I showed earlier, like spending patterns and the performance being flat. Those are not causal studies of any kind or analyses. Those are just relationship, correlational things. So there's been a body of research that has developed over the last 10 years that has become influential both in the academic circles, but also in these cases. And that's what I refer to research, is to identify, can researchers identify events that are essentially random and look at pre-event and post-event to determine whether there's or money, increases in money has an effect on student performance. Now, normally you'd say, well, if we're doing a scientific study, we'd separate people out into the group that was going to get, like a medical study. This group over here is getting more money. This group over here is not going to get the money, and we'll see what happens. Of course, you can't do that in the social science. So this research is an effort to look at events that are plausibly approach causation or a randomization kind of study. So what the Jackson-Johnson work, which was probably the first of these, is looking at events involving school desegregation, primarily in the 1970s and 1980s, and looking at when courts imposed remedies in those cases. And in many of those remedies involve spending additional money and providing additional resources to schools. So the premise of this work is those events are, in a sense, random. When that court order hits and when that additional funding hits is random. So we can look at pre-court order patterns. We can look at post-court order patterns. And we can then, in Jackson's case, tie where those students attended school from demographic records that we've got going back to the 1960s and see where those students ended up later in life. And we can look at these two groups of students that didn't get the benefit of the money drop and students who did get the benefit of the money drop, and see are there meaningful differences in their outcomes. And what this research shows, or what they claim it shows, is that if you spent $1,000 more per year for 12 years public education, you would get a 0.31 years of additional educational attainment at the end of that. 0.31 additional years of educational attainment. So that's the finding. It is statistically significant. There's a question about, is it meaningful? Is that a meaningful result? So if you spend $1,000 more a year on a 100,000 student school system, that's $100 million a year. You can do the math for 12 years. That's a lot of money. And at the end of that, 0.31 of additional years of educational attainment. So that's the finding of that study. LaFortune, Rothstein, Schanzenbach is a similar design study, but instead of looking at educational attainment, its focus is on test scores. And it's also looking at a different period, 1990s and early 2000s, with these adequacy lawsuits. But same idea, same premise. We're going to identify the money drop when the court made an order, more money went in, and we can then divide those two groups, look at the students, tie them back, understand any differences. And they find improvement in test scores when you look at those two groups based on that event that occurred. So these are, I will say, and again, I think it's an understatement to say that they're complicated studies. They're very complicated, and I am not a master of them by any means. I know enough to talk about them, but that's about it. What I do know is that there are significant and I think serious criticisms that have been leveled at these studies. And some of that, the first one is this endogenous critique. And what that really is getting at is, how sure are we that the money drop is the driving factor of the change that you're observing? Because we live in a dynamic, world, obviously. All these school districts and states are developing policies. They're changing funding formulas. Legislatures are getting, voted in or out. Governors are voted in or out. There may be any number of policy changes that are occurring in a school system, and have we accounted for all of that appropriately or not? And to be confident that we've isolated the factor that is driving the change. And so that's one of the criticisms that's out there. There's timing and agreement on these money drop events, or the SFR, which is the finance reform events. Even between the two primary authors here, there's disagreement about when these events occurred. They categorize them as obviously sort of a subjective call, like when did the court order that resulted in more money happen? Because there's lots of court orders in these cases that go on and on for many years. And so there's disagreement even between the main researchers about when these events actually occurred, which is critical to the whole study. You know, consistency of findings. Jackson didn't find an effect on test scores. Rothstein found an effect on test scores. You know, what do we make of those differences? Applicability across time and context. You know, again, I think particularly the Jackson work is pretty it was looking at a set of data and events that go back a long way. So 70s, 80s changes in funding. Can we really apply those to the level of funding and social context we have today, when we know that the level of funding pretty much for everybody is so much higher than it ever was back in the 70s and 80s, particularly in segregated school systems? The funding was really low. And so is a change in, say, spending $1,000 or $2,000 or $3,000 a kid, moving that up maybe to $6,000 a kid, is that different in kind than moving someone from $15,000 a kid to $17,000 a kid? Those are probably different contexts. I think they are different contexts. And then the last is just kind of what I would say would be, from my perspective as a lay person looking at this, the common sense argument, which is, you know, do you really believe the complex statistical models, or do you believe kind of our common experience, which is we've spent a lot more money on public education. We aren't getting the performance results that this would imply if it were true. And, you know, so that's the argument that is made, which is to the court, you know, and a judge and a court, a set of judges that are generalists. They're not going to be steeped in these complex kinds of models. You know, the argument, which has some appeal, which is, don't you think we'd see this at scale if it were true? And so those are the kinds of responses to that. So anyway, that's kind of a little summary of the work I've done in these cases and a little introduction to what adequacy litigation is about.
Thanks so much, Rocco. So let's jump into some questions. I'll kick us off, and I'm realizing that I didn't properly introduce myself. Just to very quickly do that because I wanted to keep the focus on Rocco. But my background is I'm a former superintendent from New Jersey and spent most of my career working in school districts, and I actually happened to work in a district where the state intervened. And really the rallying cry when we first came into that administration was that, this is Camden, New Jersey, for those of you that know Camden. The rallying cry at the time was Camden spending about $23,000 to $25,000 per pupil. This is back in 2013. Where nearby Haddonfield, which is a very sort of lush suburb, was spending about half of that and getting, you know, multiple times better outcomes. And so inefficiency was sort of the theme coming in. And so I've experienced this on sort of the district operation side. I'm going to come back to that point in a moment, but just thought I would give you all that context in terms of my background here. So Rocco, just to kind of share with the group a little bit, kind of give us a little bit more texture to your personal experience. When you think about your career on this broad topic of school funding and adequacy, what was sort of like the first lawsuit that either you were a part of or that you studied that was really formative to your thinking, and maybe sort of give us a few tidbits that sort of might like even dramatize sort of the bias that you've been, you know, clearly pointing out you hold on this issue.
I think back as a young lawyer, I was working with a partner who was hired to represent the state of Missouri in the Kansas City and St. Louis school desegregation cases. And those cases were unique, particularly the Kansas City case, because the remedy in Kansas City, the whole idea behind the remedy in that district wasn't sort of an internal traditional kind of busing or magnet school concept of trying to achieve integration that way. the judge in that case supervising it had this idea that if Kansas City schools could become this kind of city on a shining hill, then suburban white families would come into Kansas City, and that's how the district would achieve integration. And that plan involved basically rebuilding the Kansas City schools. I'm literally rebuilding the Kansas City schools. And at the time, it involved spending billions of dollars on new facilities. It involved bringing in foreign language teachers from Europe. I mean, there really was, in a sense, a blank check that was handed to the Kansas City schools at the time to implement this judge's vision of what would be successful in eliminating the vestiges of segregation, which was the standard that had to be achieved by the school district. And, you know, to say that there were excesses and abuses of those funds, you know, is a little bit of an understatement. And yet what was sort of sad at the end of that, and what kind of got me going, I guess, in this, is that at one time, even when the remedy started, you know, Kansas City had been a relatively large school district. It had been a 50, 60,000 school district. By the time the litigation was over, it was half that. And not only was it half that, this idea of students coming into Kansas City never materialized. The schools were largely empty. They had all of this, they had this extensive, they would have operating rooms in their magnet schools. So they would outfit, like in a health sciences kind of a magnet, they would outfit their schools with a mini operating room, like all of them. And needless to say, you know, it did not result in much of anything. Now, what happened in that case, kind of the broader political environment, was the money for that remedy came from everything between Kansas City and St. Louis. And so the rural Missouri districts and suburban districts as well were like, you know, we have needs too. And what about that? And what are we getting? What are we achieving in these two districts in terms of, you know, achieving the objectives of that court case and ultimately improving performance and doing the things that schools need to be doing? So that very much was impactful on me when I saw that effort, which was well-intentioned. I have no doubt about that. But so sort of colossally failed. And in a way that made me think about the decisions that are made. Who makes the decisions? Should a court make these kinds of decisions? Or should, you know, people who know a little bit more about schools make? And so that was very formative to my experience.
What was the time period of that?
We tried that case in 1997.
Wow.
And I have never been colder than I was in January 1997 in Kansas City, Missouri, just as a travel too. It's a lovely place, although it's a bit cold in January.
Taylor Swift usually has a big coat on at the game. So
Yeah.
All right. How would you, so when you think about the lawsuits, and you talked about the way that they're I guess adjudicated, for lack of a better word, the merits you called out are deference standard, the lack of causation, the role of expert witnesses there, and then the evidence establishing compliance. Is it, like, in your experience, are one of those typically more weighted in sort of the ultimate decision, or does it really vary across cases? Like, how do you think about kind of the importance of those kind of tenets of merit?
I think you win or lose cases on the burden of proof. And in these cases, because, you know, at whatever you can say about all of it, there's a debate. You know, it's a debate about all these issues, whether teacher quality, class size, you know, you name the issue, there's a debate on both sides, like what's best. And so if you can get the court focused on its role in these cases and not thinking I'm going to be the 8th member of the school board, or I'm going to be the 8th member of the state board, or whatever, I'm going to be the governor for the day. And you can get them thinking about, so what do we do in courts of law as opposed to school boards, and as opposed to, you know, PTA meetings and all these other things that happen in schools. if you can get a court focused on its role and ultimately, and again, my bias is coming through here, but as I sort of view these cases as, is there a minimum constitutional standard that is being violated? If there is, then there's a role for the court to come in and try to fix that. But if we're talking about gradations of performance that are above that, then really the court should not be involved. And so I think the deference level, whatever the deference level is it will be dispositive in a case. And the Texas case, the relatively recent Texas case, is a good one. It's called Morath, not Morass, but Morath.
Commissioner, right?
Yeah. And that's one where, look, all this kind of evidence was out there. Texas had a long history of litigation, both equity and adequacy litigation. Long trials, they lost at the trial court level, but it got reversed ultimately by the Texas Supreme Court because the court said, look, we're not going to come in and second guess. We're not going to come in and sort of look at this de novo and say, this is how we would do it, and therefore that's the standard we bring to bear. We're going to be deferential to some extent to the policymakers. And I think that's a hugely important framework to be able to be successful in defending those cases. And contrary, when the judge doesn't view it that way, typically the plaintiffs will prevail.
Got it. Just a couple more questions, then we'll open it up to the floor here. So you mentioned that one reality is the way statute is written, there's a lot of anachronistic language, and Massachusetts perhaps being the most anachronistic and sort of way you described it. And I recall having so many conversations with our State Department of Education in New Jersey about what really constitutes a thorough and efficient education. It's like terms I would hear over and over. Florida's amendment being a little bit more recent, but why hasn't this language been updated across states to reflect sort of the modern realities of running school systems? Is it just sort of the process of getting statute changed as simple as that, but are there other reasons?
So these are in the constitutions. And so, to get a change to even a state constitution is hard. It usually requires some kind of supermajority. And then often the voters will have to vote on it. What was interesting about the Florida example is that the prior version of that provision, and what led to the 1998 amendment was that the Supreme Court of Florida had found that the prior version, which was much more truncated, was found to be non-justiciable. So it was found that there weren't sufficient guidelines to measure whether or not the system was compliant. So the 98 amendment went in, which was an effort to try to make that more substantial and to give more direction. And then, we end up with kind of the same result. Well, not kind of, we did end up with the same result. So I think, it's hard to change just politics and the super majorities. And then the question is, what do you change it to? Right. And that, is one of the big questions in these cases, which is how do we measure? How do we measure? What do we know? And you either can be overly prescriptive and say, here's what it is, or you can be so general that it doesn't really add anything. So.
Last question. So it's hard not to think about schools that are doing more with less in hearing sort of the broader arguments. And I go back to my own personal experience in New Jersey, where charters are generally funded at about 60 cents to the dollar that district schools receive. And in Camden, New Jersey specifically, and our charters, most of them are called Renaissance schools, which are sort of hybrid district charter schools. They're dramatically outperforming the district, and their leaders and their teachers would constantly complain, if we could just get the same funding as districts or even more, imagine what else we could do, for kids and outcomes and for families and for our local communities. And in the case of Renaissance schools, they get a little extra per pupil more than a typical charter, but still less than a district. And they use that per pupil to float a bond, and they're mandated to renovate buildings or build new buildings from the ground up. And these are like $30 to $100 million investments. And these happen without raising a penny for local taxpayers. And so I guess I say all that to say, what do those examples sort of, do they influence the broader machinations of the legal system? Because it does speak to, like, with policy changes, you can run systems more efficiently and get more bang for your buck. And I would imagine that perhaps could sway some elements of the legal system, but I could be dead wrong about that.
Yeah, I think being able to focus on real life examples, because, you know, at the end of these cases, I think I mentioned we had 10 experts on our side, they had 10 experts on their side in the Florida case. At the end of that, you know, it's kind of like Charlie Brown's teacher. It all sounds like that, you know, it's like to the judge and, you know, kind of hearing it all. But if you can identify real places that have worked, our focus, one of our focus in the Florida case was to look at schools in Miami-Dade, which outperformed a lot of school districts in Florida that had better demographics, whereas similar demographics or better demographics in terms of poverty and English language learners and so forth. And so we provided, you know, I don't want to sound like it's not good evidence, but stories about how that was achieved in those schools. And that, I think, can be very compelling evidence. And because it reflects that it's possible. And it's not just possible in a one-off. And that's what we liked about using Miami-Dade. It was not a one-off. It was 350,000 students, you know. And so it was a good example with all of the things that you see in urban education, the challenges that schools face. How is it that that place was able to do that and other districts that didn't actually have as many challenges couldn't? And so I think the concrete examples of places that work are very persuasive in these cases. And generally, I think it's persuasive.
Now, there is the irony that generally plaintiffs don't want to argue for charters in the case of my example. So, all right, let's open it up. And I don't know if we're doing questions for those who joined virtually as well, but obviously we can start with those in the room.
So I'll throw out a question, which is, you know, there's a lot of criticism of standardized tests, and you seem to be relying on standardized tests here quite a bit. So the question is, does the judge believe standardized tests? Do the plaintiffs, do they make their case based on, well, kids aren't learning? Or do they make their case on there's rats in the building and the ceiling's falling down? And what makes the big impression on the judge? And what do the plaintiffs think is the way to persuade the judge that they've got a good case?
So I would say, you know, cases are different in terms of the focus that is brought to bear. I think there's a little bit of both. You know, if you've got a bad building, if you've got rodents, you will talk about rodents in bad buildings. And because that colors the impression that you would like the decision maker to have of what this place is like. So I think that certainly, you know, is part of the case. As far as test scores, I think both sides, both plaintiffs and defendants, talk about test scores. And one of the developments in these cases that I mentioned, the adoption of the Common Core and the test aligned to that, is that it's built-in evidence for the plaintiffs in many ways. I mean, they say, well, look, because it's true in every state, even in a state like this, which is, you know, a high-performing state, you're going to have half the kids not proficient on the state assessments. I haven't looked, but I bet that's true in Massachusetts. So what do you do in a state, and then if you disaggregate it down to subpopulations that are low performing, you might have 20% proficient. And so the plaintiffs will say, how can that be, Your Honor, that only 20% of the kids on what the state has adopted as the standard that kids need to know and learn, they're not meeting it. Case closed, you know? And so in that sense, test scores have become a challenge now for the state then to come back and say, well, what do these standards mean? We could adopt standards that are really low And in fact, we had really low standards historically, maybe, right? Some states. And we could have tests that are really easy, where we calibrate the cut score where 75% of the kids will pass based on our panels of review of the test. So should the court be penalizing, if you will, this is the argument that's made, a state that has chosen, which now states have chosen to have very rigorous standards and tests that are, the cut scores are set at a reasonable place. Is a state in 2024 where 50% of the kids are at grade level, are those kids less knowledgeable or less proficient, small p, than kids 10 years ago were on different standards, so that's the kind of argument we try to make, which is really that's getting into the policy. You're getting behind the policy and you shouldn't go there. So that's the way that tends to get litigated.
We've had a broadening of how parents in particular want schools to be. And I've had conferences recently about this, new models, whether it's micro schools, whether it's hybrids. So in general, school choice has gotten more popular and it has gained more momentum. On the defense side, how does that affect some of your arguments where it seems to be a lot focused on money more than anything or on technicalities? But now we've got states where there are more opportunities, and it's not just because the system is evolving, but from the outside, parents are sort of pushing for the change.
I think that gets approached depending on the state and the political and policy context of the state, and charter schools are an important part of the current policy in the state. There will be a focus on those, especially if you can identify highly successful charter schools, which, as has been pointed out, do tend to have less funding on a per student basis. And competition, certainly the Florida model, to get back to that, is we very much did focus on the A+ program that had been adopted in Florida really by Jeb Bush in the late 90s. And that allowed students to leave public schools that were not successful, that were failing schools, to go to initially both private and public. The private part got struck down, but they were allowed to go to other public schools. And that competition, especially across school districts, where you're losing funding, and they have a scholarship program for it's called the McKay program that allows special ed students to be able to move out. And so if you're not satisfied with your progress of your student on special ed, you can take your money that student generates and you can go to another district. And so there's competition over that. And oftentimes what happens, and we learned this in that case, is that whatever the problem is that the parents were having with the school district that was at risk of losing the money, that seems to get solved magically. So competition and choice and those kinds of examples have a place, I think, in these cases. And it's a mechanism that is going to be more and more, because
it's a bigger deal now.
It is. And look, online learning, artificial intelligence, all these kinds of things that are out there. I know school districts and schools are resistant, and they are, to change. All institutions are, but it's happening, and it's going to continue to happen. And so that is an important component of what we address and what we take into account.
Well, could it change the nature of litigation? I mean, because now the remedy is usually more dollars. But maybe you could have different kinds of remedies. You always have to, you could say, okay, the system's inadequate. It's not measuring up to what the state says its standards are. But the question is, would money make the difference? Well, you could show that money may or may not make the difference. So are we going to see other kinds of solutions proposed to remedy the problem?
We haven't really so far. And the reason for that is the nature of the adversarial process. So what happens in these cases is you have, set of advocates who are driving the litigation, and they have their policy preferences, which typically involve more dollars in the schools. And And then you have the state, you know, opposing that. And so those are the way that the debate is framed, as opposed to in a policy setting, legislative, hearing, or in a state board meeting where different policy options are available. It's not as well suited, which is part of the argument about why these things shouldn't be in court, because it's the advocates who make the arguments. And it's maybe a very parochial set of advocates who have one idea. It's not all of the ideas, but it isn't up to the judge to come in and say, well, I'm going to go out and research my own ideas about what's best here. That judge relies on the parties to come forward, and the parties don't necessarily represent all of these interests. So that's the limitation of a court case. But certainly, if you can get to a remedy where it isn't a budget buster, and there are things that actually would be effective, then certainly that's something that the defendant should bring to bear. And in some of these cases, there are interveners. In many cases, charter school advocates will intervene and say, look, whatever you do, don't mess up what we're doing here. And by the way, we don't get as much money and we're doing better, and take that for what it's worth. But I think the way that litigation is structured, it's difficult to get the full range of ideas and remedies and policy choices that might otherwise exist.
Got one online. Vladimir Kogan from Ohio State University says, it's interesting that the Kentucky opinion defined adequacy based on outcomes, the 7 competencies, not based on inputs. Why has adequacy litigation focused only on funding and not on other non-financial barriers to achieving these outcomes, such as teacher collective bargaining agreements, lack of teacher evaluations, and so on?
Number of the cases have focused on those elements that I would put in the category of causation, which is to say, in a school district that, or in a school or district where the plaintiff is saying this place has poor teachers, and the school district perhaps is supportive of that idea of getting more funding. The question to the officials will be, but we've looked at your teacher evaluations and they're all rated satisfactory or above satisfactory. So what are you doing with your teacher evaluation system? Is it a serious thing or not? And so we'll make, those points have been made in these cases, that it's not, it is everything that goes into producing an outcome, and certainly teacher quality and performance, and I would add to that, administrative quality is really important, because ultimately it's the principals and the administrators of the school that have to implement those and hold folks accountable, not just to the conditions of the facilities as to whether there are, rodents, which should be solved, and that's not $1 billion problem usually, or making sure that the teachers know that they're not that the principal isn't going to tolerate, mediocrity or low performance. And so we very much get into that, and we do look at the results of the evaluations, and if it's unfortunate, is almost always the case. 100% of the teachers are rated satisfactory, and that's not doing anyone a service at all. It's not doing the teachers a service, because it's obviously not true. It's not doing the students a service, because we have the performance levels we have. But there is a focus to that in these cases, and but it's an unfortunate part of what we see in these cases. And go blue.
I think we're going to end it on Go Blue.
Oh, good. That's a great ending. Well, thanks very much.
Thank you.
Thank you.